May I please the Honorable Court, my name is Shahid Khan. I am presenting an appeal. This is an appeal on the behalf of Jimmy Boy against his conviction for supplying heroin contrary to misuse of Drug Act 1971. Mr. Jimmy was convicted after 5 days trial in the Crown Court sitting at Luton. Now, moving on, I request the Honorable Court to view the second paragraph of my skeleton arguments. The second paragraph is factual background. Jimmy Boy was convicted of supplying heroin under the Misuse of Drug Act 1971 after a 5 days trial at Luton Crown Court, resulting in 12-2 majority verdict. Judge Horace Hollegen presided over the trial and Boy awaits sentencing. During the examination of Jimmy Boy, he denied acknowledged about box content. The prosecution lies on misuse of Drug Act 1971 that Jimmy have to prove his leak of information. Boy argues this infringes on his human rights, and he was thinking that the box contained medical supplies and was instructed or not to open the box. So, my lord, moving to ground of appeal, I am requesting the court to view the third paragraph of my skeleton arguments. And the third paragraph is ground of appeal. There are some appeal. The first one appeal is misdirection on the burden of proof and standard of proof. The trial judge incorrectly stated that the beyond reasonable doubt means the doubt is everyday life affair. The second ground is bias or disregard for human rights. The judge's statement expressing disregard for human rights may be considered inappropriate and could be raised as a concern. And the third ground is prejudicial comments. The judge comments about what he believes is prejudicial, and such appeals are legally grounds for appeal. So, my lord, moving to the next page, number 3. Next page number 2 and paragraph number ground number 4. Ground number 4 is evidence his quantity of drugs. The judge comments about the quantity of drugs that the defendant carries more quantity of drugs and it's sufficient. Evidence about the supplying of drugs is hug mistake of judge in creating a confession. Creating a confusion to the jury. The fifth ground is failure by trial to direct jury to ignore his views. The trial judge failed to direct the jury to ignore his views and instead express his personal opinion on guilt. It can be considered as a misdirection. And the last ground is ritual direction of Court of Appeal. The Court of Appeal has the power to accept the appeal if there is no ground but any mistake in the trial. So, my lord, moving forward to submission, pay attention to FARA number 4 of my skeleton argument. FARA number 4 is submission, and the first ground is misdirection on burden of proof and standard of proof. This is of case of Wilmington was Director of Public Prosecution 1935. Wilmington was charged with murdering his wife. Argued it was accidental. But the House of Lords, finding a misdirection in the trial, emphasized the prosecution as duty to prove guilt beyond reasonable doubt. But it was established that the standard in criminal cases is beyond reasonable doubt. Beyond reasonable doubt meaning the prosecution must prove guilt to the high standard. However, the trial judge given statement of comparing reasonable doubt to everyday doubt constitutes significant legal error. Legally, the burden of proof is the high level of certainty required for conviction, emphasizing the prosecution until proved guilty. The second ground is bias or disregard for human rights. The trial judge said, I don't care about the human right. But the ECHR Article 6 subsection 1 stated the individual have the rights to a fair and public hearing within a reasonable time, conducted by an independent and impartial tribunal established by law. The UK adopted its ECHR by the Human Rights Act 1998. Those the UK is bound to ECHR laws and statement of judge towards jury is against the above article as well mislead the jury. It's a related case. It is a related case to the human rights. As Harn, the court highlighted the need for judge demonstrated commitment to upholding human rights principle. A judge expected disregard for human rights, as seen in as my lord Judge Horigan's statement could be challenged on this appeal. The third number ground is prejudicial comments. My lord, the Crown Court give prejudicial comments to the jury that I believe that such type of people deserve lifetime imprisonment. R versus Hansen 2005 case. 2005, it is a related case, prejudicial comments. In this case, Hansen established that the judge should refrain from making prejudicial comments that could sway the jury. Any remarks implying a predetermined belief in the guilt of the accused in section 9 Contempt of Court Act 1981, it deals prohibited comments by judge that create a substantial risk of serious prejudice to proceeding the judge. So the judge comments may be assessed under this provision. And my lord, the fourth number ground is quantity of drugs is evidence. As Jimmy Boy have large quantity of drugs, but the conviction will not rely on the quantity. As the judgment R versus Smith 2012, the court clarified that the quantity of drugs will not prove the intention to supply and emphasize the need for a comprehensive assessment of evidence. So Judge Horigan reliance only on quantity might be constructed of those precedent. In the section 5 of Misuse of Drug Act 1971 requires the prosecution to prove intent to supply and misinterpretation of evidence, especially quantity may be challenged under this provision. So my lord, moving to the next page, number 3, fair number first and ground number 5. Failure by trial judge to direct jury to ignore his views. Failure by trial judge to direct jury to ignore his views might refer to a situation where a judge fails to instruct the jury properly regarding the consideration of evidence and the importance of forming their own independent views. These rules was established in R versus Dow 2012. 2012 is the trial judge fails in the trial of Jimmy. He did not guide the jury to ignore his views. And the last one ground is my lord, the judicial direction of Court of Appeal. If there is no ground of appeal for appellant, the Court of Appeal can hear the appeal in the light of R versus D 2008 EWCA crime 2557, which requires that the court hear any appeal where the court feel any mistake, any mislead trial during the trial. So my lord, in the Jimmy cases there are several mistakes such as prejudicial comments of judge disrespect for human rights and misguide for the jury and on standard and burden of proof, so the court can use his power to hear the appeal of Jimmy. That is your honor. These are my arguments, and it's submitted before the honorable court, honorable court to set aside the conviction of Mr. Jimmy Boy. So thank you.